And now, a friend who is a school teacher said that when Ofsted came to inspect her school, what she told her class of 8-year-olds was, when the nice lady comes for the special lesson we're having, if I ask you a question that you think you know the answer to, what I want you to do is just put your right hand up like this. If I ask you a question that you think you don't know the answer to, what I want you to do is put your left hand up like this. And in this way, she said, the teachers at this school will have done you proud, because you'll come away, the inspectors will come away thinking, what a sparky bunch of children we've got here, and everything will be brilliant. So in a second, I'm going to take you through just two of the developments in the field of international transfers that we've had over the last 12 months. There are far too many to cover in the allotted time. If you want to hear about the rest of them, you're going to have to look at our publication or speak to one of us afterwards. And I'm going to try and do one other thing as well, as I'm going to put the two of them head to head with each other, and I'm going to argue that one of them casts a longer shadow in the medium term in terms of the implications for us than the other one does. At the end, if we have time for a show of hands, if you agree with my conclusion, what I want you to do is put up your right hand. If you disagree, well, you know what to do. Right, so here we go. So the two cases, Thomas Bindel and the European Commission. It's the European General Court. It's under appeal. On the other side, we've got that fine, which just emerged earlier this month against TikTok Technology Limited from the Irish DPC. The decision itself, as you'll know, is not yet available. It's under redaction at the moment, somewhere between TikTok and the Commissioner. So both of them are still moving targets. So that's a caveat to what I'm going to take you through. For those of you who want a quick refresher on the facts, the Bindel case, the European Commission ran a conference on the future of Europe. You could sign up, amongst other options, in the way that thousands of websites do it these days, using a Facebook login. You'd take your Facebook login details and sign in like that. Interestingly, the Commission didn't have any SCCs for this alleged transfer of data to the US, nor did they bother with supplementary measures. Instead, the sign-in from Facebook was entirely governed by Facebook's terms and conditions. And I'm not going to take you through it, but the Commission essentially said the threshold for their non-contractual liability to be engaged in all this, when it got to court, a bit below what they thought was their threshold, they lost. TikTok, on the other hand, as I'm sure you know, it's all about remote access in China by TikTok staff to European users' data. And in each case, just have a look at the dates there. I've given them in a slightly funny way for the TikTok case. You'll see why in a second. But broadly, just as you listen to the rest of the legal reasoning that we'll come on to, just think about what we knew about the law then. So post Schrems 2, but just reflect on that as we go along. TikTok very much had SCCs. They also had supplementary measures in place, and they had a privacy notice. The punchline, as all of you know, at least in the TikTok example, 530 million euros fine for unlawful transfers and contravention of the transparency provision in the GDPR. And then there were two orders, one essentially backward-looking and one essentially forward-looking, which you see on the screen. Thomas Bindel, the individual who'd signed up for the Commission's conference, an award of 400 euros damage. So at this point, if I'm going to be holding out for Bindel, there's a clue there. It doesn't look very promising for Mr. Bindel casting a longer shadow than the TikTok case does. Let's dive into the meat of the substance of the issues. Start with Bindel. So, and these are quotations from the case, and on the right-hand side, because we don't have the decision, I should say, these are either from the press release from the Irish Commissioner or from an interview that the Deputy Commissioner gave. No doubt most of you saw it. IAPP's Joe Jones did it a couple of weeks ago. So in Bindel, the Commission said, or I beg your pardon, the court said the Commission has created the conditions for the applicant's IP address to be transmitted to Facebook, And they went on to say, following the Brea orthodoxy, look, dynamic IP addresses, we consider them to be personal data. So there is a transfer going on here. Here's the punchline. What this did, and in the absence of FCCs, this put the applicant in a position of some uncertainty as regards the processing of his personal data, in particular his IP address. And what the court said, we need to be actual and certain that this has been caused by the Commission's actions. But the threshold we're talking about here is we've put the applicant in a position of some uncertainty. That's an incredibly low bar. And what they said was not only material damage, but also non-material damage that suffered as a result of an infringement of that regulation gives right to compensation without any reference made to any threshold of seriousness. So that's the Austrian Post orthodoxy there in terms of the standard that's applied. TikTok, on the other hand, if we just think about the substance of what we know at the moment from the decision, what's in the public domain, absent the actual decision itself. So the Deputy Commissioner said, very good practical example of Schrems 2 being applied to specific facts regarding SCCs as a transfer tool. It turned out that TikTok had implemented technical and organizational and contractual measures that you would expect from a large tech company that processes sensitive personal data and lots of it. So far, so good. Where the mischief began was that they had not engaged in sufficient detail in their transfer impact assessment. And in essence, what the Irish Commissioner seems to be saying is, look, you've made the case that there is no data stored within China, and you've talked about the territoriality principles of the relevant Chinese laws. But when the TikTok employees access the data that they do remotely, they do so from within China. So where have you got to with the application of those territoriality principles? Because presumably the relevant Chinese laws have more to say about that when the member of staff is in China, as the facts bore out here. And so in a nutshell, what they said was that TikTok, who had come to the conclusion, look, we can't deliver essential equivalence, that's the standard under Schrems 1. We can't deliver essential equivalence for data processing if the data is stored on servers in China. Remote access is a bit different, and we've got supplementary measures in place, so it's okay. And the DPC in essence said, no, that can't be right. And you failed to support your own conclusion regarding the application of those principles in Chinese law. So I'll say a very quick word going over the page, and this is my final slide, about the privacy notice. And that's the reason for the funny dates that I gave you at the beginning. In October 2021, TikTok's privacy notice governing these transfers didn't mention China, and it didn't mention the nature of the transfer, in other words, remote access. By December 2022, they had cured that. That was 45 million euros of the fine. I'll just flip across to Bindle and then come to my conclusion. There were two unsuccessful claims in it. One of them I don't need to talk about. It's about subject access rights. The other one, the claimant, Mr. Bindle, also suggested, well, look, the Commission is using AWS EMEA in Munich, and its parent company is American, so I've got a problem with that. And this is a tiny ray of sunshine in the judgment from the court. They said the mere risk of access to personal data by a third country can't amount to a transfer in the court's view. So actually, we're dismissing the claim that the claimant brought in relation to the use by the Commission of AWS EMEA in Munich. So where does that leave us? On one hand, this huge fine, and it seems to me that it's extremely strict, it's an extremely literal interpretation, and perhaps important to note that the Article 60 mechanism has now been followed consecutively each of the last 5 times that the DPAs have gone through the Article 60 mechanism. So in that sense, in some ways, a very unwelcome decision, obviously, but sort of quite clear, and it's quite obvious that there's almost no room in the field of transfers for risk-based decisions. In the case of Bindle, what's the threshold now for a claim for damages? Because it looks to me incredibly low. And historically, the hurdle that you had for collective actions for data breaches in Europe was that the class members have to have suffered similar types and levels of loss. But this is basically a straight loss of control case now. The threshold is incredibly low. The collective redress mechanism, directive, I beg your pardon, gives a mechanism for mass claims of this sort. And did I mention that Mr. Bindle is the founder of a litigation funding firm in Germany? Did I mention that? Apparently it has a special area of interest. I'll let you guess what that is. And he, as presumably every other NGO does, has access to all the automated tools that you can use to scan websites like this. And indeed, as the DPAs do themselves when they do their cookie sweeps. If we have time for a show of hands, if you think I've made the case that Bindle actually has the longer term implications, put your hand up. There's a few brave souls. Some people who disagree, TikTok, they're holding out for that. A couple of people have got both hands up. That's the spirit. Thank you very much. Over to you, Ellen.